Good afternoon. Thank you all for joining me today as part of the Law After Lunch lecture series at the Martin-Luther-Universität in Halle. By way of introduction, my name is Faris Nasrallah. I am a solicitor of the Senior Courts of England and Wales and currently am based at the Max Planck Institute for Social Anthropology in Halle in Germany. The particular area of focus for my research is international arbitration and the relationship between theory and practice in arbitration. I came to the Max Planck after a decade of professional practice experience in international arbitration in London and the Middle East. And today's lecture that I'll be giving is concerning arbitration in Syria and particularly navigating post-war disputes. So, in order to kick off today's lecture, I thought it would be useful to pose the question, why arbitration in Syria? Well, understanding arbitration in any given national context can be challenging at the best of times. Undertaking such a task in Syria, which finds itself gripped by almost a decade of violence, having its territorial integrity threatened, and a significant percentage of its population forced into refugee status, makes that task of understanding the national arbitration landscape even more complex. By way of background, about a year ago, I attended a lecture on an area of Syrian law involving matters and persons in Syria. The person giving that lecture made reference to three different European legal systems, referenced international law, and even referenced issues of Roman and Greek jurisprudence and legal philosophy in a bid to try and understand what the legal situation was for those matters and persons in Syria. But there was no reference to the Syrian national law in that lecture. And obviously, for obvious reasons, I'll not name the person or the lecture that I attended, but I was surprised that this avoidance of the Syrian national legal context was reflected in the current state of available literature, at least in English and German, concerning the Syrian legal system. So I think it's important to note that scant attention has been paid to arbitration law in Syria and the Syrian legal system generally by both legal practitioners and academics. It may be that the issues discussed today contribute towards a framework for studying Syrian law. But in terms of our particular concern today regarding the role of arbitration in the settlement of post-war disputes, I suggest that it's not possible to understand the role of arbitration in resolving such disputes without a proper appraisal of the Syrian national arbitration landscape. And so, with that in mind, the lecture today is going to be divided into two parts. The first part covers an overview of the Syrian arbitration landscape, which is in three sections. The first, a brief history of arbitration in Syria. The second, covering the salient features of Syria's 2008 arbitration law. And the third, covering the proliferation of recent arbitration-related legislation in Syria. The second part of the lecture concerns the Syrian investment law and possibilities for post-war dispute settlement. That part is also in 3 sections, the first being an overview of the regional treaties and conventions to which Syria is a signatory, as well as certain Syrian bilateral investment treaties. The second considers areas for potential development across the Syrian national arbitration landscape. And the third, in a reconnaissance of sorts, looks at the potential for establishing domestic, regional and international tribunals for post-war dispute settlement. So, starting with a brief history of arbitration in Syria, if we consider the Arabic language term for arbitration, which is tahkim, that form of alternative dispute resolution, or an alternative dispute resolution technique, as it were, was a feature of pre-Islamic Arab societies. It was a method for resolving tribal disputes, but also there is evidence to suggest that arbitration was used to resolve commercial disputes in ancient Palestine, Syria, and Egypt. It's interesting to note that the concept of arbitration, or tahkim, influenced the later development of the Roman law concept of compromisum. And notably, a recognized Arab law scholar, the late William Ballantyne, took special note of the fact that in respect of pre-Islamic alternative dispute resolution, arbitration was incumbent on the individuals that had been wronged as a method to be instituted, meaning that, quite similar to the modern arbitration regimes that are established in Syria and across the Middle East, it really is the right of the claimant, in essence, to bring claims in arbitration. In terms of Islamic law and arbitration, the Prophet Muhammad considered that the deep-rooted traditions of Arabia formed an integral part of the development of Islamic law. The Prophet himself sat as an arbitrator, and arbitration became a particularly important part of the Islamic legal tradition. There are a number of Quranic references to arbitration, and particularly the use of arbitration in family matters, in the impartiality of arbitrators, in the relationship between arbitrators and judges, and also in respect of the finality of arbitral awards. So the tradition of arbitration continued from pre-Islamic ADR in Arab societies throughout the development of the Islamic law tradition, and found itself continued throughout the period of Ottoman rule in the near Middle East and across the region of the Middle East. So increasingly, arbitration became a principal method for the resolution of commercial disputes and transnational disputes across the Ottoman Empire. This is most notably evidenced by the presence of arbitration under 11 articles, dedicated articles, of the Majalla, the code, the legal and judicial code that arose out of the Tanzimat reforms of the Ottoman Empire. And those articles clearly state a number of key provisions on the conduct of arbitral proceedings, the place of arbitration in the legal system, the arbitrability of certain types of disputes, and also the finality of arbitral awards. In post-Ottoman transition to independence, after a short period of independence in 1920, Syria was placed under French rule, which lasted until 1946. And following that, the Syrian government promulgated several modern codes which were inspired both by the French codes and the French law, and also the Egyptian codes. These codes form the backbone of the Syrian legal system. They include the Civil Code, the Commercial Code, the Syrian Civil Procedure Code, the Syrian Law of Evidence, and a host of other relevant and related procedural and legal codes. Between 1953 and 2008, the National Arbitration Law of Syria was contained under one of these codes, namely the Syrian Civil Procedure Code of 1953. The particular articles where the law was contained was under Articles 506 to 534. And that position ensued, as I mentioned, until 2008, where Syria promulgated its first freestanding arbitration law. Notwithstanding that development, that important development, which I'll come on to shortly, certain parts of the Syrian Civil Procedure Code of 1953 continue to apply to arbitration even today. That's with respect particularly to the enforcement of foreign arbitral awards. Turning now to the 2008 arbitration law. So with that history in mind, it's notable that the Syrian arbitration law contains 9 chapters comprising 66 articles, which are essentially based on both the provisions of the Untitled model law and the Egyptian national arbitration law. And what I'm going to do now is take you through some of the salient and unique features of the Syrian national arbitration law of 2008. I'll try and go through these fairly quickly, and the idea really is that you get a sense of the conduct of arbitral proceedings and the local court infrastructure developed around supporting matters of judicial assistance, enforcement and annulment of arbitral awards. So, notably, under Article 3.1 of the 2008 law, the Syrian Court of Appeal has jurisdiction over all matters within the scope of the national arbitration law. A claim notice for disputes related to real property rights shall be registered in the record of real property by order of a competent Syrian court. So it's important to note that this provision does not state, for example, that real property rights are not arbitrable, but simply that if an arbitral dispute arises in respect of real property rights, that will be registered through the appropriate Syrian court. The parties can determine the applicable law and the subject matter of the arbitration, as well as the applicable procedures as one expects. The arbitration agreements are not permitted in matters contrary to public policy related to nationality, personal status, or where compromise is precluded. But interestingly, there's an exception to that, which is where the arbitral agreement concerns financial effects resulting from such matters. That's a fairly unique feature that you do not find under the public policy exceptions of most national arbitration systems. Under Article 13.2, there's no requirement for arbitrators to be of a specific sex or nationality unless agreed otherwise by the parties. Again, that's a fairly unique feature insofar as most other national arbitration laws are silent on the matter of sex or nationality of arbitrators. Under Article 14.5, a court order rejecting the request of an appointment of an arbitrator shall be subject directly to the Syrian Court of Cassation. Again, there are 2 ways of looking at that possibly. The first being that, issues of appointment and removal of arbitrators cut out potentially 2 rounds of procedural actions in the Court of First Instance and the Court of Appeal and go straight to the Court of Cassation. Although the other way of looking at it is that a disputant or claimant in respect of such issues only gets 1 bite at the cherry. Under Article 15, assaults against arbitrators due to or during the exercise of their duties face the same penalty applicable to assaults against judges. For reference, the penalty for assaults against judges under Syrian law, under the Syrian Penal Code, is temporary imprisonment. Arbitrators have a duty to disclose circumstances likely to raise doubts as to their impartiality or independence. That's both upon accepting their mission to sit, but also as it occurs or may occur during the arbitral proceedings. For our German law students, they'll recognise the principle of competens, and that doctrine applies to the mandate of arbitral tribunals under Article 21.1. The parties are free to agree on the geographic place of arbitration, whether in Syria or abroad, unless otherwise agreed by the parties or decided by the tribunal. Arbitrations will be conducted in the Arabic language, so that's a fallback position, not necessarily that all arbitrations will be conducted in Arabic, but if the parties leave matters and do not specify another language or come to an agreement about another language, then the default language of the arbitration will be in Arabic. Hearings will be held in camera, in secret, unless the parties agree otherwise. Tribunals have the power on their own motion to request parties to instruct experts, but also to hear witnesses. Notably, arbitral awards must specify the fees and expenses of the arbitration, and also the way in which those fees and expenses will be allocated between the parties. The competent Syrian court can, on its own motion, rule on the annulment of arbitral awards, which, if the content of such awards violates Syrian public order, and awards shall be final and not subject to appeal, and shall be binding and have the authority of res judicata. So the final point here is, I've noted that the ruling of a competent Syrian court to annul arbitral awards for any reason under the provisions of the Act, which I won't set out here, which are provided under Article 51 of the law, can be challenged before the Syrian Court of Cassation. So you can see here that the Syrian National Arbitration Law of 2008 reflects the national arbitration laws of most developed legal systems and countries with developed arbitration systems. There is no time for me to go over the relevant court decisions issued by Syrian courts in respect of the national arbitration law, but it should be noted that the provisions of the 2008 Syrian arbitration law have been tested in the Syrian courts, and that there is a growing jurisprudence which is being developed in respect of these national law provisions. The third part of the overview of the Syrian national arbitration landscape is in respect of the proliferation of arbitration-related legislation in Syria. So, in addition to the national arbitration law, the Syrian state has, over the past 2 decades, promulgated legislation in a number of areas of law which either relate to the provisions of the 2008 arbitration law or the practice of arbitration generally in Syria. For our ease of reference and understanding today, I've categorized these legislative acts under 2 headings. The first is legislation containing substantive provisions that govern arbitration of certain disputes, and that includes matters relating to customs, real estate investment, telecommunications, and other industries. The second type of legislation is that which endorses arbitration by mere reference or pays attention to the future establishment of arbitral infrastructure. and that is contained, those type of references are contained under the Syrian laws relating to insurance, maritime and competition law. So by way of example, in respect of the first type of legislation, the first branch, which is legislation containing substantive provisions governing arbitration, we might consider the Syrian telecommunications law of 2010. Now, this law contains 7 specific articles on dispute settlement. Under the heading Arbitration, Article 53 of the Telecommunications Law contains a number of provisions relating to the resolution of disputes between licensees in the telecommunications sector by arbitration. So the law generally seeks to establish, pursuant to the mandate of the Syrian Telecommunications Regulatory Authority, a specialist settlement of disputes committee, which will have judicial competency specialised in examining civil and commercial disputes arising in the field of telecommunications. So with respect to that Settlement Disputes Committee, it's stated that the parties may submit a dispute to arbitration by reference to the Settlement of Disputes Committee. Upon the decision of a council of the Board of Commissioners to be established by the Syrian Telecommunications Regulatory Authority, specialist arbitration rules for resolution of those disputes will be established, although they will be subject to the provisions of the Syrian Arbitration Law of 2008. That same council, to be appointed by the Syrian TRA, shall issue a list of arbitrators' names who are experienced, competent and certified by the Syrian TRA to be used by the parties in the formation of arbitral tribunals to resolve those disputes. So you can see under that one example that in addition to the national arbitration law governing arbitration in Syria, that with respect to particular industry disputes, as in telecommunications, there are supplementary provisions which one must be aware of. So turning now to the second part of today's lecture, I'm here assessing the Syrian investment law landscape and also the possibilities for post-war dispute settlement. So in terms of an overview of the regional treaties and conventions to which Syria finds itself a signatory, as well as various bilateral investment treaties, it's important to recognise that as well as being signatory to the New York Convention and the ICSID Convention, Syria is in fact a signatory to various regional treaties and conventions that contain provisions that relate to arbitration and the resolution of disputes generally. For our reference, these regional treaties and conventions include the Arab League Convention on Enforcement of Judgments and Arbitral Awards of 1952, the Inter-Arab Investment Guarantee Corporation of 1971, the Unified Agreement for the Investment of Arab Capital in Arab States of 1980, the Organization of Islamic Conference Investment Agreement in 1981, the Riyadh Convention on the Enforcement of Judgments and Arbitral Awards of 1983, the Amman Arab Convention on Commercial Arbitration of 1987, and the Islamic Corporation for the Insurance of Investment Credit of 1992. So you will see, if you turn to any of these regional treaties and conventions, that the provisions that relate to arbitration really give pride of place, in a way, to the technique of arbitration as an ADR mechanism to resolve disputes that come under those treaties. By way of overview of Syrians' bilateral investment treaty activity, Syria has concluded over 40 bilateral investment treaties between 1975 and 2010. 15 of these BITs are between Syria and other Arab League states. These BITs appear in largely asymmetrical form. That's to say that they do not have a particular format or structure that is applied in rudimentary fashion throughout all of their investment treaty relations, but most of which provide for recourse to arbitration among other forms of dispute settlement in respect or in the event of investor-state and state-to-state disputes. In order to get a sample of these variations in Syrian BITs, listeners or viewers may wish to turn to the Syrian-Egypt BIT, Syrian-Moroccan BIT, or the BITs concluded between Syria and Lebanon, the UAE and Jordan, each of which have quite important variations on their dispute settlement infrastructure. Interestingly, for our German students and our German audience, the BIT between the Federal Republic of Germany and Syria, which was signed on the 2nd of August 1977, contains provisions for the resolution of disputes between contracting parties pursuant to arbitration. That's under Article 9. But crucially, is absent any express reference to methods for resolving investor-state disputes under that treaty. So some of our law students watching this will probably be thinking ahead about some of the jurisdictional issues that may arise under disputes of that nature between investors and states under the German-Syria BIT, but certainly, I mean, it seems like there's scope for additional work in that respect, but also possibly a lifetime of jurisprudence and dispute resolution work arising out of that. But in terms of areas for potential development in the Syrian national arbitration landscape, if one is to speak of a national arbitration policy in Syria, you can see from the provisions that have been covered already in this brief overview that there is pervasive inclusion already of arbitration, both as a form of dispute settlement but also as an idea that runs throughout a network of different legislation in the country. This legislation, as you will have seen, bears features of its historical relationship, of Syria's historical relationship with arbitration, but also is forward-looking, at least in terms of established legislation, towards the accommodation of rules in line with the international rules-based system. There is certainly scope for the development of Syrian arbitral institutions, that much is clear, for practitioners working in arbitration in the Middle East and internationally. It will come as no surprise to note that there isn't a recognizable arbitral institution in Syria that rolls off the tongue, and there is certainly scope in that respect for the development of such institutions. In terms of developing a wider arbitration infrastructure, there is also scope for developing local court expertise, particularly as the national arbitration law signals that the Court of Appeal will be the point of first contact for disputes arising out of or in connection with the national arbitration law. So in that respect, judicial training obviously will be a constant requirement. but also the publication of court judgments, both to allow a systematized development of the national law of arbitration, but also to allow academic research into how that policy or approach to arbitration within the country is developing over time. Other areas for potential development include the experience of international commercial courts. So in this respect, there are a number of examples that one may look to. Regionally, of course, there are the examples of international commercial courts in Dubai, in Bahrain, in Qatar, but also more recently in China, in Singapore, and in Germany, where we are now. In 2019, the Frankfurt International Commercial Court was established. And so, while some of these courts do not have or have not proliferated considerable jurisprudence or test cases in order to try out the infrastructure and develop a sense for how to manage these types of disputes, the international tendency towards establishing courts of this nature is something that is certainly there to be considered. So, if we turn to the potential for establishing domestic, regional, and international tribunals for post-war settlement, there really are a number of options here which one can consider. Of course, I stand here in a sense with some form of a crystal ball looking into the future. But in order to guide that process of consideration, you can consider historical examples, international examples, and regional examples. Historically speaking, there's the phenomenon of mixed arbitral tribunals, or MATs, as they are known. There's really a growing interest in studying the jurisprudence proliferated by these mixed arbitral tribunals. But by way of background, these were tribunals constituted to resolve disputes arising out of or in connection with the First World War and later the Second World War. They were of international composition, neutrally intended, independent, often constituting recognized jurists or authorities from various national legal systems. And I'm pleased to say that at the Max Planck Institute, there is a lot of work being done on the history of these mixed arbitral tribunals and the development of the jurisprudence surrounding them. So there are certainly historical examples that one can consider. Internationally speaking, there are a host of special tribunals and special courts established, which one can also look to for inspiration. Regionally speaking, there is, of course, the US-Iran Claims Tribunal, which, following the 1979 revolution in Iran, has developed a considerable amount of jurisprudence and procedural and practice experience in handling those disputes, which arose out of the revolution in Iran. So there are, of course, experiences there which one may consider. With that in mind, of course, one recognizes that post-war dispute settlement will, of course, be predicated, one hopes, on a cessation of violence, but also, procedurally speaking, as lawyers, it will largely come down to the number of claimants, the type of claimants, the industry claims, and defining, for example, issues such as the onset of the war, other timing periods, or significant issues of interpretation of that nature. There's also the issue of enforcement and what the enforcement landscape would look like in any given tribunal or court. So with those issues in mind, there is really, in a way, a whole host of considerations that one would need to take on board before developing or suggesting an infrastructure for resolving post-war disputes. And that, in a way, leads me to the current position, the default position, or the fallback position, whichever you want to call it, which is that really there is an argument for saying that these disputes could be resolved on a case-by-case basis. Of course, that is, or may be, problematic for a number of reasons, but given the background that we've gone through today and the fact that there is a national arbitration infrastructure in Syria and that the legislation relating to arbitration is pervasive across the network of various industries and microsystems within the Syrian arbitration and legal landscape generally, there is an argument that actually, given the fact that Syria is already a signatory to the New York Convention, is already a signatory to the ICSID Convention, and is developing a local jurisprudence for judicial assistance and enforcement of arbitral awards, that these cases may at some point be hosted on a case-by-case basis. Of course, given the current situation, the regrettable situation, this is probably not going to be possible within Syria itself, not safely at least, but it's still an issue for consideration. And on that point, I say thank you to everyone that is watching. I hope that the lecture today has given you some kind of an insight into what the national arbitration landscape in Syria looks like, but also in terms of further research on the Syrian arbitration and legal system generally, the importance of delving into and looking into the existing laws within the country as a method for understanding matters internationally that are of importance. And so I open the floor to questions.